Thank you very much, Mr. Chairman. Professor Levin, I'll start with you. Pick up where you left off. Congress shouldn't meddle with this jockeying that's going on between the judiciary and the regulatory bureaucracy in terms of how the courts should decide what deference to give them to how they interpret the regulators' regulations. But, I mean, this is the very core of why Justice Scalia was, after the fact, questioning the merits of a decision that he was a part of, and that is, why wouldn't Congress want to assert its legislative powers when what we're seeing more and more, we don't need anecdotal evidence, we can just look at the statistics of the rising number of regulations that are written each year, and particularly the number of regulations that come out based upon old laws written 20, 30, 40 years ago, where the bureaucracy comes back and says, you know what, we think that law is out of date now. We'll just retool our regulations. Doesn't have to go back to Congress at all for Congress to write a new law. All that has to happen is for us to rewrite this regulation. The courts will look at it, and the courts will say, well, you know what, if that's what the bureaucracy thinks that regulation means, then we should give deference to that. So I very much disagree with that assessment, and I'd be happy to give you an opportunity to respond.
Thank you for the chance to respond to that. First, I do want to dissociate myself from Mr. White's claim that Justice Scalia was rejecting Chevron. Whatever he said in private conversations, in his public pronouncements in the City of Arlington case in 2013, he strongly reaffirmed it, challenged the dissent for taking it on. In his Michigan decision shortly before his death, he
well, let's get to the core of my point, which is what's the role of the Congress if the regulatory bureaucracy never has to come back here when they see a need for a change in the law, they just change it themselves?
Well, Mr. Chairman, as you may know, I've not been a fan of the committee's regulatory reform efforts.
I don't care whether you're a fan or not.
But what I'm saying is,
question.
Even because Congress can't effectively deal with the scope of review in 2 or 3 words because it creates enormous complexities. It's just a few words. There'll be endless debates about what it means. I'm not saying it's beyond your province. I'm just saying you can't effectively do it.
What do we do when a regulatory bureaucracy says, you know what, we're going to reinterpret this decades-old law and write new regulations because we think those are more pertinent to the situation
I think you should rewrite the laws to say what you want them to mean.
Sure, but that's this Congress compared to a Congress of 40 years ago. If we can't get it back here and they can bypass the Congress by writing regulations that they want to write, and for us to change that, we have to have it pass through the House, have to have it pass through the Senate where they have archaic rules requiring a 60-vote majority, and then we have to withstand a presidential veto if the president so chooses, whereas a bureaucrat, all they have to do is rewrite regulations on laws that were written long ago and in no way contemplated the new uses that they're imputing to those old laws. What do we do about that?
Well, I think you have mechanisms of oversight, but I think you almost have to recognize that when you give Congress agencies authority to act, then they exercise that authority and they have the legal right to act.
So what's wrong with telling the courts you look at the law yourselves, don't give deference to one side or the other in the court case?
If Congress tells the agency to use discretion, the court would be defying the statute if it didn't allow the agency to use the discretion.
Well, I don't think many statutes overtly say use discretion. I think what we do is we don't fill in all the details. We expect them to do so within the black letter law that is in front of them. And when they don't do that, and then the courts look at those regulations, I think the courts are well within their authority to make their own decision rather than give deference to the bureaucracy, because you're just simply, both the courts and the Congress are then transferring power to the executive branch that we shouldn't.
Sometimes what we call deference is simply recognizing that they used legally delegated authority that the court may not second guess. And that is often considered a question of law. And if you pass a statute saying the court shall not allow the agency to use that discretion, which this statute appears to do.
Professor Duffy, would you like to jump in here?
I certainly agree that he just made a point that Jack Bierman made in his testimony, which is that a lot of times the practice is not really deference. In Chevron itself, and this is actually exactly what you said, that sometimes Congress writes a framework and expects the administrative agency to put in reasonable rules. That actually was what was happening in Chevron. And I was just looking back at my article that dealt with this some years ago. The Solicitor General appearing before the court in Chevron itself did not come up with some newfangled deference test. Instead, they began their legal argument with quoting the rulemaking power of the agency in full, which is what this Congress gave to the agency. And the basic point of my testimony, I think, and also I think Professor Bierman's testimony, is that this legislation would force the agencies to justify their authority on the basis of statutory law. And that's, I think, the core of what's at stake here. And I very much believe that Congress does have something to say about this. The entire APA, which is something that all of us law professors teach in administrative law and have taught for decades, that is Congress's view about how agencies should be structured. I think that's perfectly appropriate for a representative democracy to have the greatest deliberative body in that democracy think about how power should be allocated. So I strongly disagree with the idea that Congress shouldn't have anything to do with it. That's the very statute that I teach through a course called administrative law. So I think that your legislation is perfect to try to force the courts to go back and say what we're really looking for is to find agency authority if they have it.
Thank you. I agree. Thank you, Mr. Chairman. You're back.